Once that issue is addressed, we will reset a date for all pending motions.
The special judge presiding over Mickey Stines' murder case is being asked to recuse himself after a video surfaces showing him sitting next to Judge Kevin Mullins at an event a week before Stines shot and killed Mullins in his chambers. I take a look at Stines' request that the judge step aside and the video at the center of it all. I'm Angenette Levy, and this is Crime Fix. Have you ever wondered how we are able to share so many clips from breaking news cases as they are unfolding? Well, here's a little secret. Opus Clip is an all-in-one AI editor that makes it a breeze to cut, create, and upload videos across any platform. Through AI, Opus Clip generates B-roll, it reframes footage, and it even cleans up audio. Just visit opus.pro/crimefix, sign up, and upload, and within minutes, you will have perfectly edited clips ready to go. For TikTok, Shorts, or Reels, it's a one-stop shop. Having Opus Clip means our producers can post viral updates in an instant. This is the most powerful tool for sharing ideas and editing like a pro. So go to opus.pro/crimefix to create your videos today. When Mickey Stines shot and killed Judge Kevin Mullins in his chambers in September of 2024, it was absolutely shocking. Security cameras recorded the shooting, and the incident left so many people asking questions about why a sheriff who swore to uphold the law would take out his service weapon and shoot a man he had worked for and a man he had considered a friend. Since that time, Stines' lawyer has said his client was suffering from some mental health problems, and body-worn camera footage from the moments after the shooting shown that Stines was certainly acting oddly.
Come on, guys. No, come on now, guys.
I'm not sticking nothing.
No, now.
There's two body cams running, Mickey. It's all recorded and there's a digital recorder running.
No.
That will be, look, it'll show you that it's running. Look.
Come on now, guys.
No, look,
Come on
Mickey,
now.
we've known each other a long time. Look, it is recording. That one's recording. Clayton has a backup recorder running.
No, now, come on, guys.
What do you think? Slow down.
We can't talk in the hallway of the courthouse, Mickey.
Yeah, there's
You know
people
that.
here.
People here. We don't want to.
I mean, there's people in that room, there's people in that room. We can't do that.
So what's the problem?
I'll get another one. I'll put one on me. You won't take let me, okay? But I can't be in the room.
Guys, come on, man.
Mickey,
Come on.
Is there somebody that you trust other than us that you would prefer to be with us?
Now, Stines was paranoid. There was no doubt about it.
do you want to talk at all, Mickey?
Earlier you said you were going to talk about it. Hey, listen, Mickey, if you don't want to talk, that's fine. I ain't going to force you to, okay? We're not going to force you. If you don't want to talk, that's your right. You don't have to.
Yeah.
I read you your rights. Well, and you know, you're the sheriff. I mean, you know just as much as we do.
Okay.
But it's up to you.
If I can see my daughter in person here.
Before you leave. Is that what you want?
At the jail.
At the jail?
Yeah. At the jail, through the screen, on the phone, I want to see my daughter in person. And then after that, I'll tell you everything at that jail.
Well,
in front of cameras. Video recorded.
Where's your daughter at?
Huh?
Where's your daughter? How do we track her down? Where's she at?
She was at LCC earlier. She was at LCC. I talked to her.
So, now, Mickey, I want to just kind of, for your daughter, let's talk about this, for your daughter, okay? If she finds out that her dad is being arrested for shooting the judge, and she's in high school. I didn't know how old she was, so I didn't know. So she's in high school. What is she, a senior? That's going to be hard.
She will want to see me. She will want. Now, come on, guys, be fair to me now. That's all I'm asking.
I am being fair. That's the only thing I just wanted you to think about that. How is she 18?
Be fair to me now, guys.
Well, hold on. Is she 18?
Be fair to me now.
No, I'm asking you.
Come on, I want to see my daughter in person.
Is she 18?
I want to see my daughter in person.
How
You got
old
a
is she,
kid?
Mickey?
Because if
I do have a kid. I've got grandkids.
Yeah.
I got 5 grandkids. 5 grandkids.
Listen to you.
I just want to see my daughter, man.
If she's not 18, we're going to ask your wife. We have to ask your wife if it's okay. You know that. Is she 18?
Christine and Shawn both said they were both on their way here. When they were in here, there was all kinds of people in here just running around chaotic. So, how am I going to tell you what happened?
To the judge?
Yeah. You know, Christine LaShawna said my wife and daughter's on their way.
No, but you just said, how are you going to tell us what happened? Everybody's running around chaotic.
It was. I just want to see my daughter.
Is she 18? How old is she? If your wife's out there with her, if she ain't 18, we can ask if that's okay. But if she's 18, we just ask your daughter. So that's what I'm getting at. If she's not 18, we have to ask your wife. Do you think they're outside?
LaShawna and Christine said they was on their way. Let me talk to them too.
You want to go ask them about it?
Hit that button.
Now, this is recorded.
Guys, come on now. Be fair to me now.
Mickey, we're not being unfair to you.
You want to drink water?
Yeah, now be fair to me, guys. Y'all gonna kill me.
You don't?
No. Is Mickey's wife and kid out here? Do you see them?
Since that time, we've learned through court documents that Stines had been evaluated following his arrest, and those evaluations determined that he was in active psychosis at the jail and had been given medications prior to those evaluations. Stines' lawyer, Jeremy Bartley, told me in March of 2025 that his client's mental state could be a major issue at trial.
Well, so in terms of what the specific mechanism or diagnosis is at the time, I'm going to defer questions on that. But I will say this. There was no doubt to anyone that was around Mickey in the days following the deposition, prior to the deposition, and certainly after the deposition and the days leading up to what you saw in the video, that he had not slept, rarely, if any, had not slept in days, that his demeanor was completely off. People described him as paranoid and just not acting in accordance with his normal demeanor. Now, again, I don't want to get into specifics. The statute requires that there be a mental disease or illness or defect. I'm not going to get into that now. I'll wait until we hear more from the experts. But I'll just say this: there's zero doubt that the combination of his mental health, which was exacerbated by the pressure put on him because of this deposition, played a role in what we saw. And within that mental health defense, you really have two things. One, which I've said from the beginning, for the preliminary hearing, we think sets the ceiling for the Commonwealth, is extreme emotional disturbance, right? Because that's a partial defense. And that goes to, at the moment he acted, did his emotions become so enraged, disturbed, or inflamed that he acted almost, basically out of control. I think it's evident that something happened within those chambers, and we'll get into more of that as the case progresses. But there was a moment at which his emotions, in a worst case for our client, it's extreme emotional disturbance, which would get us to manslaughter. But we believe that there's more, and we believe that that we will put on evidence that he was unable to conform his conduct based upon some mental health issues that were going on during that week.
Now, in the background of all of this is the fact that Mickey Stines and the sheriff's office was being sued by a woman named Sabrina Atkins, who was an inmate at the jail. And one of Stines' sheriff's deputies, Ben Fields, had sex with Atkins in Mullins' chambers in exchange for help getting a GPS monitoring bracelet so she could be out of jail on bail. Fields pleaded guilty to a charge related to the allegation, and Stines had been deposed in the lawsuit days before the shooting. And there have also been allegations that Judge Mullins, who worked with women who were struggling with addiction through the courts, was involved in taking advantage of the women by having sex with them himself. Now, these are allegations. We have not seen any videotapes that are alleged to have existed or anything like that. A special judge, Christopher Cohron, was appointed to preside over Mickey Stines' murder case. Cohron is from Bowling Green, Kentucky. That's about 4 hours west of Letcher County. Judge Cohron will decide several key motions in Mickey Stines' case, including whether he gets bail and whether a change of venue will be granted in the case. The Commonwealth, and that's the prosecution in this case, is asking for a change of venue, and that's actually pretty rare. Usually defendants are the ones asking for a change of venue, but not in this case. Several residents of Letcher County have signed affidavits, including the Commonwealth's attorney for Letcher County, saying they don't believe Mickey Stines or the Commonwealth can get a fair trial in Letcher County. The Commonwealth filed those affidavits in support of its motion for a change of venue. But now Mickey Stines is questioning whether Judge Cohron should be on the case at all. And it's all because of this video. This video is from September 12th, 2024, just 7 days before Judge Kevin Mullins was killed. You can see Judge Mullins sitting at a table during a meeting of the Kentucky Judicial Commission on Mental Health.
Good afternoon, everyone, and welcome to our September quarterly meeting of the Kentucky Judicial Commission on Mental Health.
Mullins is sitting there with some colleagues, and then a man sits down next to him, and that man was Judge Christopher Cohron, the same judge who is now presiding over the murder case of Shawn Mickey Stines. Mullins and Judge Cohron sit next to each other with an empty seat in between them for less than an hour. They don't speak to one another. At one point, Judge Mullins speaks to the group.
As someone who was actually working on a program and actually experiencing a problem, and within months having that problem addressed was just very wonderful. Also, I was able to speak quite a bit about Senator Adams's Women's with Dignity Bill 1 and 2. And in all these different pieces of legislation, we were able to show how these particular pieces were able to positively influence and even save lives of our Kentucky citizens. So it was a great opportunity.
Now, this video has led Mickey Stines' lawyer, Jeremy Bartley, to file a motion asking Judge Cohron to recuse himself or to have him disqualified. Bartley quotes the legal standard for recusal, writing, "A judge must disqualify themselves in any proceeding where their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts." He continues, "The statute provides in relevant part that a judge shall disqualify himself in any proceeding where he has a personal bias or prejudice concerning a party or personal knowledge of disputed evidentiary facts concerning the proceedings or has expressed an opinion concerning the merits of the proceeding. The statute also requires disqualification where a judge has knowledge of any other circumstance in which his impartiality might reasonably be questioned. Similarly, the Kentucky Code of Judicial Conduct provides that a judge shall disqualify himself or herself in any proceeding in which the judge's impartiality might reasonably be questioned, including but not limited to the following circumstances. The judge has a personal bias or prejudice concerning a party or a party's lawyer." So Bartley believes that Judge Cohron, sitting a seat over from Judge Mullins during the meeting 7 days before his murder, could possibly impact his ability to be impartial. Bartley writes, "Had this video been taken even months prior, then the appearance would not be so concerning. However, this video creates an impression to the public that there is a bias in favor of his colleagues seated next to him. As noted in a recent court order from the court, videos create a strong presumption that is extremely difficult to rebut." Bartley wrote that he believes this judge has made some decisions already that may have shown a lack of impartiality. Bartley writes, by way of example, "At the juncture when the foregoing was discovered by the defense, a hearing on bond was set. However, despite the consent of the defendant, the mental health report from the state's own expert has been disallowed as evidence in the bond hearing. While the undersigned is restrained by the previous order from discussing the findings in the report or the contents, our client made multiple revelations to the examiner that fall into the category of evidence that would conflict with this judge's professional knowledge of the deceased. At this point, there has been no legal basis as support for the refusal to unseal the KCPC report. While that issue is one to be addressed further at a later date, the objective observer would rationally believe there is inherent bias from the video, and this would lead the judge to prohibit this normally admissible report from coming into evidence." Bartley wrote that things, in his view, would be different had Cohron disclosed the existence of this video much earlier. All right, so to discuss this motion to disqualify the judge in this case, I want to bring in Mark Weaver. He works as a special prosecutor in the state of Ohio, just north of the bluegrass state of Kentucky, and also sits as a judge sometimes. So, Mark, reading through this motion, basically, Jeremy Bartley, the attorney for Mickey Stines, is saying that Judge Cohron didn't disclose this interaction or this sitting next to Judge Mullins 7 days before he was murdered, and should have done so. And so he should step aside from the case. What are your thoughts?
Mark me down as skeptical about this motion. Let's start from the premise that this is not the judge that would normally have a case. This is a specially assigned judge. Normally, when you see motions for disqualification, it's because the regularly assigned judge has a conflict because he lives nearby or knows the people in the courthouse. So we start from the premise that a specially assigned judge should be somebody who doesn't have a conflict. Well, what's the basis of this conflict that they're claiming? He was at a judge's meeting, sitting next to the judge who would eventually be murdered. Now, maybe you could say he was sitting next to the defendant who did the murdering. That might be a conflict, but those aren't our facts here. It's sitting next to the judge who's going to be murdered. I noticed when I watched that video, and your viewers could see it, that there were placards or name cards around the little square about where the judges were sitting. I've been to a lot of these conferences, particularly as a prosecutor. Many times the staff has laid out where everybody sits. And so you just go where your name tag is, your name placard, and kind of assigned seating, if you will. So perhaps they were together because the staff put them together. But simply being at a professional event with the judge who would eventually be shot strikes me as a very weak reason to suggest that there should be a disqualification.
And there was a seat in between them, an empty seat in between them. It doesn't appear that they speak to one another. So, and Bowling Green and Letcher County, I mapped it. They're 4 hours apart, just about 4 hours drive apart. So, yes, a lot of judges do know one another, but from the video, I don't see any indication that they did know one another, or that they were like buddy, or that they were even interacting with one another on a meaningful level at all.
Well, I'll give you an example that might help viewers. At least in Ohio, a lawyer donating to a judge's campaign is not enough to disqualify the judge. That's considered to be part of the normal doing business as a judicial candidate. So when I go to prosecutors' conferences, and I go sometimes twice a year, from prosecutors from all around the state, I will often shake hands. How are you? Good to see you again. How's the family? What's new? Talk about sports, talk about the weather. But then I've never been to their home. I don't know their spouse. It's really just a friendly professional conversation. Even that sort of relationship would not be enough to disqualify somebody.
Jeremy Bartley he writes in his motion, the fact that these two men served on this very worthwhile committee is not enough to draw an objectively reasonable inference of impartiality. However, there will be proffered evidence that contrasts with the presentation seen on the video. It is difficult to understand how this close proximity with Mullins in both time and distance would not lead the reasonable observer to impute a bias in favor of disbelief of negative statements and the propensity to disallow the same. And he's talking about, like, basically that he's sitting next to him at this conference. Maybe he's not going to believe some of the evidence at trial where there's discussion about Mullins possibly being involved with the trafficking of these women or taking advantage of these women. That's like the allegation that's been made. That's been the talk, and that this somehow was part of what led Mickey Stines to shoot and kill Judge Mullins, his longtime friend and former boss, like that he thought his daughter and wife had been taken, and it was part of this whole thing. So maybe this judge sitting next to Judge Cohron, sitting next to Judge Mullins, is thinking to himself, I'm just not buying this.
Yeah, this is all so speculative. It's all so attenuated. I've never been a criminal defense lawyer, but I know they have a job to do. Some of my friends were prosecutors and now they're criminal defense lawyers. It's fine. It's a perfectly good profession. But I understand that they have to work with the facts in front of them. The facts they wanted to have a video of these two arm in arm at some meeting, smoking cigars and laughing and swapping stories. They don't have that video. They have them sitting at what looks like a very boring meeting. I'm not saying the topic isn't important, but it looks like a very boring professional meeting. And trying to spin that up into some conflict relationship really does strike me as far-fetched.
So basically, this judge, I would think, is going to seek an opinion from someone. Is that how this would work? Would this judge, since he adjourned the prior proceedings, we discussed that, would he go seek legal advice or an opinion from, I don't know, a judge's counsel? What do you think that he would do? And then, he'd have to come back and then look at this, or, the Supreme Court would have to look at it. What would happen?
In most states, there are two steps towards disqualification. The first is a request for the judge to disqualify himself. And the U.S. Supreme Court, out of a case from West Virginia about a decade ago, gave standards for when judges should voluntarily disqualify themselves from cases. If the judge decides that he or she does not need to disqualify themselves, then a party can ask, in this case, I think it's the Chief Justice, that's certainly the way it is in Ohio, whoever appointed that judge, to reconsider that appointment and disqualify the judge who didn't want to disqualify themselves. So it's a two-step process typically. Hey, judge, I think you're conflicted. Would you step away? If the judge says no, then, hey, Chief Justice of the Supreme Court, would you disqualify and appoint another special judge? I think that's how it's going to go here.
Mm-hmm. I find it hard to believe that this judge, Judge Cohron, is going to go back, review the video, and say, you know what, you're right. I can't be impartial because I sat one seat over from Judge Mullins and may have not even realized it was Judge Mullins at the time until you just brought this to my attention. That could very well be the scenario. Do you see this Judge Cohron saying that? Judges, they're human beings, and they're loath to say, I can't be impartial. You don't see that very often. That usually comes before the case starts or at the very beginning of the case. That's why he's on the case in the first place. Everybody on this case is specially appointed. The judge, the Commonwealth's attorney, that's why the AG's office is on this, and not the Commonwealth's attorney for Letcher County.
Yeah, you mentioned in your intro that I've been a special prosecutor in more than a dozen counties in Ohio, and I've received more calls than just those cases. And so at the very outset, when I get a call, hey, Mark, could you please be a special prosecutor in such and such county involving this person and that person? If I know those people and I know that I can't be objective, I will deny the appointment even before it's made. So I have to think this judge would have done the same thing. Oh, what are you kidding? I'm so close with him. We always go out to dinner together, and he tells me his life story and all of his secret personal knowledge. I can't be on that case. Well, that didn't happen. The judge accepted the appointment. Didn't have to. The judge accepted the appointment. So I can't imagine that this video, here you are sitting next to each other at a very boring judicial conference. Now you have to get off. I just don't see it going anywhere.
I want to talk just briefly now about the motion for a change of venue filed by the Commonwealth, which is not something you often see. The Commonwealth has now filed a bunch of affidavits from people in Letcher County, including the Commonwealth's attorney, Matt Butler, who is not a part of the case. But basically, all of these people are saying, I don't believe Mickey Stines or the Commonwealth can get a fair trial in Letcher County. The Commonwealth is basically trying to beef up its case, saying, look, we have these sworn statements from residents of Letcher County, one being the Commonwealth's attorney, who I think that's very odd since he took himself out of the case. But what do you think about that, the Commonwealth filing these affidavits in support of their motion?
Let me address that last question first. If a prosecutor steps away from a case, that prosecutor should have nothing to do with the case after that. So that was very curious to me that the prosecutor who stepped away from the case, appropriately so, would get involved by way of filing an affidavit. So that's concerning to me, at least a little bit. The larger point is I read these affidavits. I actually set aside some time to read them. I thought I might need 15 minutes, but each of them is, I think, 3 sentences long. These are what we call in the law conclusory affidavits, where they don't offer any proof. They just say, trust me, I know something, and
Right.
therefore you can't get a fair trial here.
There was no survey done, nothing like that. It's just like, I live here, trust me, I can tell you for a fact.
Yeah, I'm not saying it's unethical. What I'm saying is it's really weak tea, if you will. If you had said, I have spoken to 200 people in the last month at Christmas parties, and 150 of them have all said, I have an opinion about this case and I won't be able to shake it. That's at least some evidence. It's kind of curious that you'd be keeping track of the numbers like that. Or if, as you mentioned, a survey, that's been done before. You do a public opinion survey and you present the results to the judge and say, we need to move this case out of the county. This scientific survey says that 2/3 of the people say they could never change their mind. That's the sort of thing. Doesn't have to be a survey, by the way. The law doesn't require a survey. But there needs to be something more than what I call, or what the law calls, conclusory affidavits that say, yep, trust me, I know, can't get a fair trial here.
Yeah, it seemed a little hinky to me. Mark Weaver, thank you as always for your time. I appreciate it.
Thank you.
And a date has not yet been set to argue the motion to disqualify Judge Cohron, and he hasn't responded to the motion. When he does, we'll let you know. Mickey Stines remains being held without bail at the Leslie County Detention Center. And that's it for this episode of Crime Fix. I'm Angenette Levy. Thanks so much for being with me. I'll see you back here next time.